Everybody, please thank Bryan Dunklin for coming.
Thank you. Big hand for George and Tim. You all are blessed to have these guys as part of your faculty today. These are players. They are in the market. They know what they're doing. They are not just selling seminars. A little bit of contact information on me. I will have business cards that I'll leave out front, and you will be sent a copy of my video presentation so you can take notes. But there's a lot more information on here than I can possibly cover this morning, so I'll send you the PowerPoint presentation so that you can watch it at home or get more details. This is how you get in touch with me, and it'll be on my business card and on the PowerPoint. A little bit about me. I taught on the faculty of SMU for 23 years, taught real estate law and business law, and I chaired the real property section of the Dallas Bar Association, about 820 lawyers back in 2004. I'm a former general counsel of a national bank. I've got a very limited topic that I can cover today, so I'm not going to be able to entertain questions until afterwards, but please write down your questions, and then I'll make myself available at the break. So I'm going to go through these things very quickly, but I've been practicing law for about 30 years and had a license as a real estate broker for about 27 years. And I've done a variety of different things, including doing a lot of speaking to the State Bar of Texas and to lawyer and real estate groups around the state. I will ask you to be considerate of the other seminar attendees and don't speak to one another during the presentation, primarily because it's a distraction to me. I love the Einstein quote, if you're carefully driving a car while kissing a pretty girl, you are not giving the kiss the attention it deserves. I'm the pretty girl in this scenario, so I'm hoping you'll pay attention. The disclaimer is fairly obvious. I can't do anything other than give you general information. Please consult an attorney with respect to your particular circumstances. I'm available at $250 an hour, and I bill in increments of 1/10 of an hour. And as I say, I encourage questions. I love the quote that he who asks a question is a fool for 5 minutes. He who does not ask a question remains a fool forever. Don't hesitate to ask the question. The only foolish question is the one you don't ask. We're going to talk today about that back office and how to set it up and how to protect yourself. My primary focus today is going to be talking about limiting your liability. I'm going to talk about some contractual provisions, some legal entities that you can use to limit your liability. The idea is not how much you make, it's how much you keep. And you don't want to make the money and end up losing it to creditors or to claimants. And even if you've got other creditors, you want to set up your business so that you are more likely to keep it. But primarily, we're going to talk in terms of issues related to taxes and real out-of-pocket costs, because these are dollars that are going to be clearly affected even if you never get sued. Now, what are the options? Well, sole proprietorship. You just operate in your own name. Interestingly enough, I don't necessarily discourage this as long as you do it right, you think it through, and you protect yourself in other ways that I'm going to talk about and show you. But the most common legal vehicle in today's world for operating your business is a limited liability company. So I'm going to talk most about that. We're in a blessed situation in Texas in that we're the 8th state in the country to pass something called a series limited liability company, and it is an amazingly fluid vehicle that one time you pay a filing fee and one time you create the legal entity, and then as long as you observe the other formalities that are required, you can have a virtually unlimited number of legal entities into which you will put each asset and each contract and or each business that you're going to operate without having to have another filing fee and without having to pay a lawyer again to set up another legal entity. It's essentially a wholly owned, or not necessarily wholly owned, but a subsidiary that has a separate asset base, a separate liability. We're also going to talk about corporations. Interestingly enough, I'm real high on C corporations. Most people think, wait, a C corporation, that has double taxation. I don't want to have anything that involves double taxation. The sophisticated player has at least one C corporation because it has a medical reimbursement plan. It allows you to deduct through your business unreimbursed medical expenses and unreimbursed things like co-pays and deductibles and things that insurance doesn't cover. You can deduct through your C corporation, but only through your C corporation. It also has a fiscal year that allows you to do some staggered planning that will allow you to defer your taxes. And then finally, it has a separate tax bracket. And the first $50,000 is taxed at 15%. Most of my clients are in a marginal 31% tax bracket. And if you use a C corporation correctly, you can keep more money. And that's what it's all about. Because you're going to reinvest the first $50,000 that you earn through the C corporation. You may be able to reinvest all of those monies, and you're only paying 15% instead of a higher marginal tax bracket that you'd be paying if you had a pass-through entity. So double taxation isn't necessarily a bad thing. Even if you have to pay the 15% dividend tax and you pay all of the profits of the C corporation through to you as a dividend, 15% of 85% is 27.75%. And that's a lower tax bracket than 31%. So when you understand these issues, you're going to be able to save money, and that's what this ought to be all about, not just limiting liability. Limiting liability, in my opinion, is grossly oversold by most gurus, and what you ought to be focusing on in terms of limiting your liability is liability insurance. Now, I don't sell liability insurance. I kind of wish I did, because I'm constantly pushing my clients to think in terms of having liability insurance. Now, today we're going to be talking about contracting. And as long as you contract through the legal entity and you sign your contracts correctly, you're going to be able to limit the liability under the contract to the assets of the entity that is doing the contracting. But don't believe that just because you have a limited liability entity that you are completely and always safe from claims of creditors, because your individual conduct is always going to be subject to challenge, and you're going to be personally held accountable. You can't throw acid in somebody's face and say, oh, I was only acting as the manager of my limited liability company. You can't drive the corporate car, run through the red light, kill somebody, and say, oh, I was driving the corporate car and I was only acting in my capacity as president of the corporation. That's not going to relieve you of your personal responsibility. You're never going to be able to be relieved of liability if you're guilty of fraud or violating Deceptive Trade Practices Act. Your conduct is always going to be subject to challenge, and don't believe that there's a panacea out there involved in having a separate legal entity. I'm not generally going to talk today about general partnerships or limited partnerships, even though a limited partnership up until about 5 years ago used to be the preferred way for large real estate investments to be held, because we didn't have to pay any franchise taxes in Texas. And even though it was more expensive to set up and you effectively had to set up 2 entities, the primary reasons for doing that related to raising money in the private capital markets, which is very tough to do these days, and not to pay a franchise tax. We changed the rules in 2006. Now, limited partnerships pay franchise taxes. And if your lawyer's recommending a limited partnership, it may be because he's going to make a whole heck of a lot more money if you set up a limited partnership and a separate entity to serve as the general partner. I'm also not going to talk about limited liability partnerships, which are primarily designed for professionals like architects, doctors, lawyers, CPAs to serve, where they have to buy at least $100,000 worth of insurance and pay $200 per partner. And then finally, I'm going to generally avoid discussing Delaware or Nevada LLCs or corporations. Most people hear a lot of gurus pushing those issues. Usually those gurus have some way of making some money themselves if you set up a Nevada or a Delaware LLC or corporation. But if you're going to use that company in Texas, it has to register to do business in Texas. And you have to have a registered agent here in Texas. There's a $750 filing fee just to register those foreign corporations to do business in Texas. Now, I'm going to fly through some of these slides, but I wanted you to have them anyway, so please forgive me if I give them very short shrift, because frankly we just have another 20 minutes. There are 5 major factors, I guess I've organized them as 4 factors, that you ought to consider whenever you think about setting up a legal entity. Whether it has limited liability or provides some form of limited liability is one of the factors. I don't happen to believe it's the most important. I think the most important should be the actual costs, out of real pocket dollars that come out of your pocket, hard-earned after-tax dollars that you have to pay to set these things up. Legal fees, filing fees, CPA fees to prepare extra tax returns. The cost of, in some instances in Texas, you're going to have to pay franchise taxes if you have very large organizations with lots of money coming in, or if you have multiple organizations that end up having substantial gross proceeds, you're going to end up paying franchise taxes. These are real out-of-pocket costs that provide limited liability. But the income tax considerations can actually save you money in addition to providing some level of limited liability, like the C corporation issues I've discussed. And then finally, we're going to talk about control and logistical issues, but I don't have enough time to talk a lot about them. Just recognize that that's a factor that you need to consider. Now let's talk about sole proprietorship, because many of you may decide that you don't want to spend the money in legal fees and filing fees to set up a separate legal entity. When you are contracting to buy a piece of property, sometimes you actually increase your credibility with a buyer, with a seller, if you can be set up as a separate legal business. You look more substantial. You look more professional because you are the vice president of your corporation, or you're the senior manager of your limited liability company. It makes it look like you're bigger than perhaps you are, but in reality, you may in fact be negotiating from a perspective of very, very few assets and therefore risking virtually nothing. And part of this business is about taking the fear out of doing the business. So if you can operate a corporation or an LLC or a series LLC and not have virtually anything to risk from the perspective of not necessarily performing your contract, you're much more likely to go out and sign up that deal. Now again, that's not going to excuse you from fraud or deceptive trade practices, but at least in terms of the contractual liability, you can limit it to the assets of the legal entity. So let's talk about some of the issues if you remain as a sole proprietor. Well, first of all, you're probably going to want to file an assumed name. It's cheap to do it. $20, I think, is the last time I looked, was the filing fee for a 10-year assumed name certificate. You do have to file it in the principal place of business where you're operating, and you won't be able to get a bank account in the name of that separate name if you don't file an assumed name certificate. And technically, you violate criminal procedures and there's civil remedies if you don't file an assumed name certificate. So if you decide to do business as an individual but in another name, you need to file an assumed name certificate. They're inexpensive. You can go online, Google your county clerk, Collin County Clerk, Dallas County Clerk. They'll pop up a form for an assumed name certificate. You can print it out, pay the $20 fee, file it with the county clerk. Now you can get a bank account. Now you can advertise and do business in the name of the assumed name that you filed. But if you're going to contract in your own name, you're going to have unlimited personal liability with respect to that contract. So let's do some things to protect ourselves if you're going to operate as an individual. First of all, use the Texas Real Estate Commission promulgated forms. I think George is going to talk about some of these issues later. But the bottom line is paragraph 23 gives you the right to terminate the contract for a nominal consideration. I provided you a copy of that paragraph. Fill in the blank. Remember that it is important that you actually deliver the $10 or however much you give to the seller, and time is of the essence. There are only two provisions in the Texas Real Estate Commission contract forms when time is of the essence, and you must strictly perform in accordance with those deadlines that are stated in the contracts. And those are in this paragraph if you're going to terminate the option, and in the real estate third-party financing addendum that provides that you're going to get third-party financing. If you're going to get out of the contract because you couldn't get your third-party financing, you must give the notice of your decision or your inability to get that financing by the deadline, or time is of the essence and you will lose that right. So fill in that dollar amount, give that dollar to the seller, and then docket the deadline, and now you have a right up until the deadline to terminate that contract. And in so doing, you can now, with impunity, sign virtually any contract. Virtually any contract. Can't read the sign, but or is it? I guess that's a
laptop.
It's a laptop. Okay. No wonder I couldn't read it. And if you don't pay, or you don't fill in the blanks, or you don't give the notice, then you don't have the right to terminate the contract. But think about it. If you'll check box 23 and fill in the form and give the money to the seller, you can sign any contract and get out of that contract for 30 days. The next thing I'm going to recommend that you do, and I've given you the information on how to do that. So the other thing we want to do to take the fear out of buying a piece of property is to limit the remedy of the seller to the retention of your earnest money. And then, of course, negotiate for as little earnest money as possible. How do you do that? The Texas Real Estate Commission contract form does not provide for a limit of the remedies that the seller can take against you if you don't perform the contract. It says it can sue you, it can force you to buy, or it can terminate the contract and keep your earnest money. And this is the default clause in paragraph 15 of that TREC contract form. And George, I apologize to the extent I'm being redundant, but it'll be in my PowerPoint, and it specifically addresses issues if you're going to operate as an individual. But you can edit that TREC contract form if you're the buyer. Don't let somebody tell you you cannot use those forms or that you cannot alter those forms. Real estate brokers are required, and salespersons are required to use those forms, and they can't alter those forms without the consent or the involvement of a lawyer. But you're a principal of these transactions. You can make changes to those contracts, and this is how I recommend that you change it. You can strike through the entire second line that limits, that provides for a remedy for the seller to sue you or to force you to buy. Just completely eliminate that remedy and leave as the seller's sole remedy the right to terminate the contract and keep your earnest money, and then you're going to have nothing more to lose than just that contract earnest money. George is going to talk a lot about this, and Tim is going to talk about this, but obviously if you're in the wholesaling business, you want the right to assign this contract. I provided you with some language that you can put in special provisions on how to assign the contract. But we don't want to just assign the contract. We want to be relieved of liability if we do assign the contract. This is a provision that says that if the buyer's assignee, the person you're going to assign that contract to, agrees to assume the obligations under the contract, that you, the original buyer in the contract who's assigned the contract, is now no longer liable on the contract. Make sense? All right, I'm going to talk for a minute about limited liability companies, and I'm primarily going to run out of time in talking about virtually anything else. So I'm going to focus on this issue. Limited liability companies are relatively new creatures. The first one, I've got the history of LLCs and the new series LLC on the PowerPoint presentation for a reason. Lawyers didn't initially adopt the use of limited liability companies because they didn't have any history. Now we've had a great deal of history. All 50 of the states have limited liability companies. The IRS, as recently as 1996, finally came to the conclusion of how we were going to be able to have them treated for federal income tax purposes, and that's one of the great benefits of a limited liability company. If you form a new LLC in Texas, there's a $300 filing fee. But in order to expedite it, you'd have to pay a $25 fee to the Secretary of State. If you use your credit card, they only charge you the credit card fee, which is $8.10. So all of my clients that are smart use their credit cards to pay the filing fee. It's $308.10 as a filing fee, and you can create a limited liability company. The IRS has, as of 1996, come up with a system where you can check the box, and you get to decide how that LLC is going to be treated for federal income tax purposes. Now, one of the very, very cool things is if there's a single member LLC, if the sole owner is an individual and only one individual, one of the options that you have is to have the legal entity, the separate LLC, disregarded for federal income tax purposes. And what that means is, and that's the default, by the way. If you don't make an election, that's going to be the default position. That means you don't have to file a separate federal income tax return. On your 1040 form that you normally file as an individual, you're going to have a Schedule C or a Schedule E for the business, and you're going to run your income and expenses of that LLC through on your 1040 form, Schedule C or Schedule E. Now, there is a margin tax in Texas that is the franchise tax. In the original year, it was $600,000 in gross proceeds you've got to run through your LLC to have to pay a tax. The second year, in 2010, the figure was $1 million. You had to have more than $1 million in gross proceeds before you had any franchise tax. We're back to the $600,000 level at this point in time, and the state legislature is in session, right? So hold on to your wife and your wallet and your kids. State legislature's in session. One of the things I will typically agree to make available is there are some new statutes right now on the governor's desk that will affect LLCs, and I'll be happy to provide you with analysis of that. Tim's been nice enough to provide me with your email addresses. If you don't want me to send you something, including other materials from time to time, please let me know, or just opt out of the emails that we send you. But otherwise, I'll provide you with analysis of what's getting ready to be signed into law. The governor has until the 19th of June to sign the new statutes, and analysis of how the new statutes are going to affect LLCs and corporations is going to be important to how you run your business. Generally, members, managers, and officers are going to have limited liability if they pay their franchise taxes. You're not going to have any liability, and the contract liability is going to be limited to the assets of the LLC, which can be minimally capitalized. So it's a powerful tool for limiting your liability. A couple of important things. One, pay your franchise taxes. Two, sign the contract properly. Now, I've provided for you, and I'm betting that George and Tim may have it in their documents, ways that you should properly sign contracts to limit your liability. But if the buyer is an LLC, make sure you put that in as the buyer. And then on the signature line, make sure you always, always, always sign in your capacity as the officer or the manager of the LLC, because you're making it clear to the seller that you're not signing this individually. In the truck contract forms, I probably should have shown it, there are two buyer lines. And they assume that there may be a husband and a wife that's involved. And all you have to do is on buyer 1, put the name of your LLC, strike through buyer number 2, and just write the word buy. And then you're going to put your name and your title after it, and always, always, always sign your documents as your name, comma, manager, or president, or authorized officer. I've even gone so far as to recommend to clients that when they have their checks printed, when you have your checks printed, go ahead and tell the printing company to print the checks so that below the signature line you've already got your name, by your name, and your status as officer or manager. Same thing is true for a corporation. I've provided that information to you in this slide. And then the next slide shows if you've got a limited partnership, which some of you may have. Very quick show of hands. How many people already have a corporation or an LLC? Okay, good idea. You're doing your job right. Make sure that you keep your... One of the problems with a corporation is you've got to maintain corporate formalities that effectively have been overruled by statute with respect to limited liability companies. So it's a lot friendlier environment to operate an LLC. I charge $350 as legal fees and provide you with more service than you're going to get online if you try to create an LLC. The company agreement is the critical device. And if you don't have a series LLC, you're going to find the real hot new item in town is going to be having a series LLC where you can effectively put each and every asset into a separate box or series and limit the liability of that the liabilities of that box, that series, to the assets that's in that series. And the same thing is true with respect to whomever is the owner of the series LLC parent, and with respect to all of the other series. Now you're going to have to keep records that maintain the accounting separately for each asset, but you can imagine the power of this. You're not going to have to pay a $300 filing fee and attorney's fees every time you want to create another separate entity. Corporations have shareholders, directors, and officers, and they're generally going to be have limited liability for contractual liability, except in the case of their own personal conduct, which we've already addressed. And by the way, this is why I say liability insurance is so critical. Your liability insurance carrier will typically cover your LLC or your corporation and its officers and employees And that liability insurance won't cover fraud, won't cover contract breaches, won't cover Deceptive Trade Practices Acts unless you pay an extra premium. But most modern lawyers are smart enough to realize that if they're going to get paid, it's going to be because there's a liability insurance carrier involved in the transaction. And they will always figure out a way to allege negligence so that you've got the right to pick up the phone and call your liability insurance carrier and put them into a position where they have a duty to defend you, not just on the liability claim, but with respect to all of the claims. Now, they don't have to pay a claim that's not covered by their policy. They don't have to pay it if there's a fraud found against you or a breach of contract. But the lawyers who are the plaintiffs that would sue you have figured this out. They're going to get, if they don't settle, 98% of cases do, and it's because the insurance companies step up and write a check. And if it doesn't settle and they go to trial, the smart plaintiff's lawyer, before it goes to trial, is going to withdraw the other claims against you, because the worst thing that can happen to that plaintiff is to win the case, but to have the insurance company say, aha, you found him guilty of fraud or breach of contract, and guess what? We don't have to pay that claim. So they're frequently going to reduce or eliminate all the claims except the negligence claims. It's a lot easier for a plaintiff to prove negligence than it is in an intentional tort or fraud, right? I love the Napoleon quote, never ascribe to malice that which can be explained by incompetence. I hope you get the idea. It's a lot harder for people to believe that somebody is purposefully injuring them than to believe that perhaps they weren't very careful in the manner in which they did what they did. Now, what I've done here is to tell you about S corporations and C corporations, the forms you have to file, but importantly, I've listed the benefits of a C corporation, which can help you save taxes. One of the benefits of an S corporation is if you pay yourself a minimal salary, then the rest of the monies that are paid from the S corporation are considered dividends, and because they're dividends, they do not have to cover, you don't have to include additional taxes like Social Security and Medicare. And that helps you save real money, right? Finally, you are going to have to pay some minimal salary in that situation, but the S corporation is not susceptible to double taxation. It's an information return only, and then there are K-1s that allocate to the shareholders their respective share of the income or losses. I've gone through and listed each of the factors and then shown how they apply to each of the various legal entities in the schedules with these next slides, so I'm going to race through those, but they're there for your information if you want to look at them, including legal fees, what you can typically expect in the way of legal fees. And obviously, that's going to be dependent upon a particular lawyer, but you can at least look and see what I typically charge, and otherwise you're just going to have to shop. These are the franchise tax issues. Let's see. Did I lose my mic?
I think it'll come back.
I'm back? Okay. Don't forget, you're going to have continuing costs of operations with CPAs and franchise fees. I've now explained what a limited liability company is. I'm going to go on to explain the history of LLCs, and more importantly, for your future considerations, the history and the governance rules relating to series LLCs, because the series LLC is really going to create an efficient vehicle for you to be able to operate your business and keep each asset separate. If one is foreclosed, you're not going to end up having a separate claim. The foreclosing lender, the party who sues the Series A, isn't going to be able to reach Series B. And what's beautiful is the statute couldn't be more clear. I've left you with the language in the statute. Let's see, what else have I got?
See if your mic's working, Ted. Yeah, mine does.
Okay, hello? Okay, well, I'm out of time, so that makes it easy.
All right.
Okay. I've explained the difference between an LLC and a corporation, and then I've also given some information relating to the people who have contributed to my... I know a good joke when I steal one. To steal from one person is called plagiarism. When you steal from many, that's research. So I've properly attributed to the people from whom I've stolen, borrowed, and or used their opinions and or information, and provided this at the end PowerPoint. Thank you, George. Thank you, Tim. Appreciate the
All
opportunity.
right, put your hands together.